Thank you for joining us today. It was a lively first session, and I hope we'll have a lively second session building up to tomorrow. As you'll note, one of the things that we've been focusing on is kind of the institutional structure and the ways in which ideas of justice get put through not just kind of activists' lenses, but through the actual requirements, the imperatives that institutional structures compel. So our next speaker will address issues like that. He's Daniel Badansky, and he's going to talk about the role of justice in United Nations institutions. So I'll introduce Dan, and then I'll introduce the faculty discussant and the student discussant as well. So Dan, Professor Badansky is the Regents Professor at the Sandra Day O'Connor School of Law, College of Law at Arizona State University. He served as the Climate Change Coordinator at the United States State Department from 1999 to 2001. His book, The Art and Craft of International Environmental Law, received the 2011 Sprout Award from the International Studies Association as the best book that year in the field of international environmental studies. His latest book, International Climate Change, co-authored with Jutta Brunet and Lavanya Rajmani, was published by Oxford University Press in June 2017 and received the 2018 Certificate of Merit from the American Society of International Law as the best book in a specialized area of international law published the previous year. He is a member of the Council on Foreign Relations and is a graduate of Harvard, Cambridge, and Yale. The faculty discussant will be our own Dan Esty. Dan is the Hillhouse Professor at the Yale University with primary appointments in the Yale School of the Environment and the Law School, with a secondary appointment in the Yale School of Management. He also serves as director of the Yale Center for Environmental Law and Policy and as director of the Yale Initiative on Sustainable Finance. Professor Esty is the author or editor of 13 books, including the prize-winning Guide to Corporate Sustainability, Green to Gold, and dozens of articles on environmental and energy policy, and connections to regulatory approaches, corporate strategy, sustainability, performance measurements, competitive trade, and economic success. His recently edited volume, A Better Planet, 40 Big Ideas for a Sustainable Future, was named the top book of 2019 by the Financial Times. From 1989 to 1993, Professor Esty served in a number of senior positions in the U.S. Environmental Protection Agency. During this time, he led EPA's regulatory review process and helped negotiate the 1992 Framework Convention on Climate Change. From 2011 to 2014, he returned to government to serve as the commissioner of Connecticut's Department of Energy and Environmental Protection. We're glad to have him back in the House, though, so glad he's back with us. The student discussant is Michaela Foster, who is a PhD candidate at Yale School of the Environment. She's an environmental social scientist studying environment and natural resource government. In her research, she examines the development of natural resource policies and their impact on sustainable forest management and land use change. She holds an MS in natural resources from North Carolina State University and a BA in environmental science and policy from Duke University. And with that, I'd like to welcome Dan Badansky.
Hi, everyone. I'm sorry I can't be with you in person, but it's a pleasure to have the opportunity to discuss with you today the issue of climate justice. I'm an international lawyer rather than a philosopher, so my talk today will focus on the UN climate change regime and how it addresses the issue of climate justice. Since I'll be talking a lot about the UN climate change regime, a little background will be helpful for those of you who may not be so familiar with it. I like to describe its history as a play in 4 acts. In the first act, states established the basic framework of governance for the climate change issue in the UN Framework Convention on Climate Change. The second act focused on negotiating legally binding emission targets in the Kyoto Protocol, but these applied only to developed countries, not to China, India, Brazil, and other developing states. The third act focused on trying to broaden the regime beyond the relatively small share of global emissions covered by the Kyoto Protocol. This involved developing a bottom-up approach in the Copenhagen Accord, which allowed states to nationally determine their mitigation actions, an approach that a much wider range of countries has been willing to accept. The final act is involved in negotiation and adoption of the Paris Agreement, which incorporates the Copenhagen Accord's architecture in a legally binding instrument. The Paris Agreement is sometimes described as a Goldilocks solution between the top-down, highly differentiated, rule-oriented approach of the Kyoto Protocol, shown here on the right, and the bottom-up flexible approach of the Copenhagen Accord, shown on the left. Like Copenhagen, the Paris Agreement allows states to nationally determine their mitigation contributions. But in contrast to Copenhagen, it imposes stronger procedural rules to promote accountability and ambition. Like Kyoto, the Paris Agreement is a legally binding instrument, but unlike Kyoto, countries' emission reduction pledges are not legally binding. Finally, Paris finds a middle ground between the sharp differentiation between different groups of countries in the Kyoto Protocol on the one hand, and no differentiation on the other. It abandons the Framework Convention annex structure and instead allows states to self-differentiate their mitigation actions through their nationally determined contributions. With that brief background on the UN climate change regime in mind, let me turn to the issue of climate justice. In my talk today, I'll be addressing 4 questions. First, what do we mean by climate justice? Second, how does the UN climate change regime address the issue of climate justice? Third, is the UN climate change regime itself just? And fourth, what causal role have beliefs about justice played in the development of the UN climate change regime? The first question is conceptual. What do we mean by climate justice? This is a harder question, I think, than one might think. We all have intuitions about what seems unjust. For example, the fact that poor developing countries who've contributed very little to the climate change problem are the ones who will be most hurt by it. That seems clearly unjust. So to some degree, we know climate injustice when we see it. That's the comparatively easy part. The hard part is to define what would be a just outcome. It's not easy to determine exactly who owes what to whom, because that depends on a whole series of questions that don't have clear answers. What I'd like to do today is to give you some sense of these complexities. They help explain why incorporating climate justice into international agreements like the Framework Convention or the Paris Agreement is so difficult. Initially, it's useful to distinguish 3 different types of justice: distributive justice, corrective justice, and procedural justice. Distributive justice has to do with how we distribute the burdens and costs of addressing climate change. Corrective justice addresses the question, what do those responsible for causing the problem owe to those suffering harm? Finally, procedural justice deals with how decisions should be made to address climate change. It deals with issues of participation, transparency, and decision-making. Much of the debate about climate justice concerns distributive justice. The key issue of distributive justice is how to allocate the permissible budget of future emissions among countries, and how much each country will therefore need to reduce its emissions. Here's a non-exhaustive list of some possible principles for distributing the burdens of reducing emissions. The grandfathering approach starts from the status quo and measures burdens relative to a state's current emissions. It might call for comparable percentage emission reductions from current levels. The responsibility approach, in contrast, focuses on historical emissions. The principle here is that countries that have contributed more to the climate change problem have more responsibility to address it. The capability approach focuses on ability to pay. The idea here is that rich countries should do more to address climate change than poor countries because they have greater capacity. Finally, the equality approach posits that each individual has an equal right to share the atmospheric commons, and that per capita emissions should therefore be equalized over time. Now, depending on which of these distributive justice approaches we adopt, how we calculate a country's fair share of future emissions is very different. For example, a country's share of current emissions may differ widely from its share of historical emissions. If we look at current emissions, China is the biggest emitter. But if we look at historical emissions, the US is the biggest emitter. So the responsibility approach will put a bigger burden on the US relative to China than the grandfathering approach. Similarly, countries' relative share of total emissions can differ a lot from their relative levels of per capita emissions. Again, comparing China and the United States. If we look at total emissions, China is the biggest emitter, but US per capita emissions are much higher than those of China. These different approaches to distributive justice yield very different allocations of future emissions. The pie chart on the left shows an allocation of future emissions for different regions based on a grandfathering approach. The pie chart on the right shows an allocation based on population, while the middle pie chart shows a blended approach. You can see that the sizes of the different wedges for the different regions vary widely, depending on which approach to distributive justice we adopt. There are many other parameters that are also important in deciding how to allocate burdens in a just manner. Here's one example. Do we look at all greenhouse gases or focus only on carbon dioxide, which has a much longer atmospheric lifetime than other greenhouse gases and is central to limiting temperature change to well below 2 degrees? Countries with high CO2 emissions will come out better if we take a multi-gas approach. Countries with low CO2 emissions, in contrast, will come out better if we focus only on CO2. Here's another example. Do we focus on emissions from burning of fossil fuels? Or do we also include emissions from deforestation and other land use change? Emissions from land use change represent about 1/3 of cumulative CO2 emissions. For a country like Brazil, which has high emissions from deforestation, it makes a big difference whether we include emissions from land use change in our equity framework. How we account for trade can also make a big difference in calculating a country's fair share of global emissions. Lots of emissions are associated with the production of goods in one country that are then exported and consumed elsewhere. For example, a car that's produced in China and exported and sold in the US. The emissions associated with the production of the car are sometimes referred to as embodied emissions. This map shows the flows of these embodied emissions through exports of products from the producing country to the consuming country. Should we attribute these embodied emissions to the country where the good is produced and the emissions occur, or to the country where the product is consumed? Big consumers, such as the United States, do better if we do our carbon accounting on a production basis rather than a consumption basis, while big producers such as China do better if we do the reverse. Here's another complexity. If we adopt the responsibility approach to distributive justice, what should be the start date for holding countries responsible for their historical emissions? Do we hold countries responsible for their emissions from the beginning of the Industrial Revolution on the theory that the country has benefited economically from these emissions and should be held responsible for them, even though they weren't aware at the time that the emissions were causing any climate change harm? And if so, do we apply any discount rate to early emissions compared to more recent emissions? Or do we say that states should be held responsible only for emissions that occurred after people understood that greenhouse gas emissions contribute to global warming? The choice of start date for counting historical emissions has big implications for a country like China, which had very low emissions until recently. If we look at cumulative emissions since 1870, China's cumulative emissions are only about half those of the United States. But if we look only at emissions since 1990, China's cumulative emissions were the same as the US as of 2018. And since China currently emits much more than the US, the Chinese share of cumulative emissions is now bigger than the US, and this differential will continue to grow. Finally, how do we account for historical emissions from the combustion of fossil fuels that were extracted in one country and then consumed in another. Oil exporting states have benefited tremendously from the use of fossil fuels. So should they bear some responsibility for the burning of these fuels? The bottom line is that what constitutes a just distribution of emission reductions depends heavily on the approach to distributive justice we adopt and on the parameters we use to calculate emissions. These charts show the total emission budgets from now until the end of the century for various countries, including the US, Japan, Russia, China, India, Brazil, and also for the European Union. The bars represent the emission budgets for 8 different equity approaches, as well as for business as usual and a cost optimization model. You don't need to worry about the details, but this chart should give you some idea of how big the differences are between the 8 different equity approaches. To take the US, for example, which is shown in the upper left, under some equity approaches, the US has already exceeded its emission budgets for the 21st century and must have negative emissions. Under other approaches, the US still has some emissions left in its budget. So the issue of distributive justice raises many difficult issues to work out in practice. Let me turn briefly to corrective justice. In contrast to distributive justice, which focuses on how to share burdens going forward, corrective justice is backward-looking and concerns how to correct past wrongs. For example, by compensating for the damages caused by climate change. Corrective justice raises many issues, but let me highlight 2. The first issue is who should get compensated for what? If the idea is that countries should be compensated for the harms they suffer due to climate change, we need to be able to determine exactly what harms can be attributed to climate change. And as this slide illustrates, we have very different levels of understanding of different types of climate events and very different levels of confidence in attributing particular events to climate change. So there are significant issues calculating the damages that need to be compensated. The second issue concerns who's responsible for providing the compensation. And this takes us back to the issue of which emissions a country should be held responsible for. Its total cumulative emissions going back to the beginning of the Industrial Revolution, or its emissions after the world understood that greenhouse gas emissions are causing global warming. Moreover, should countries be responsible for all of their emissions, or only for their emissions above some threshold level necessary to meet people's basic human needs, what are sometimes referred to as survival emissions? Finally, let me turn to procedural justice. What procedures are fair in making decisions about climate change? With respect to states, should we require consensus? On the one hand, consensus prevents one state from being coerced by others. So if we're worried about the problems of domination and exploitation, a consensus rule helps guard against this. On the other hand, a consensus rule makes it difficult to adopt decisions and is one of the reasons why progress in the UN climate change regime has been so slow. Alternatively, should we allow voting? And if so, on what basis? A one state, one vote rule, which would give Vanuatu the same weight as China, even though its population is orders of magnitude smaller. A system of weighted voting, for example, based on population, which would allow a few big countries to make decisions for everyone else, or weighted voting based on vulnerability. There's no clear answer. In addition, there are issues about how non-state actors should be allowed to participate, including industry and civil society organizations. And since climate change raises issues of intergenerational equity, there's also the question of how to represent the interests of future generations. So there's lots of scope for disagreement about what procedures are just. So far, I've been talking about what we mean by climate justice and discussing some of the complexities into thinking about distributive justice, corrective justice, and procedural justice. Now let me turn to the descriptive question. How does the UN climate change regime address the issue of climate justice? The first thing to note is that the regime doesn't generally use the language of justice. The term doesn't appear in the UN Framework Convention at all, and it appears only once in scare quotes in the Paris Agreement. Instead, the term equity is used, generally in the same sense as distributive justice. But although the UN climate change regime doesn't use the term justice, it addresses justice issues in many ways. And let me mention 3. First, one of the core principles of the convention is the principle of common but differentiated responsibilities and respective capabilities, which basically says that what states should be expected to do to address climate change is a function of their responsibilities and their capabilities. Second, the Convention recognizes the particular needs of particular groups of countries that are vulnerable to climate change or will be particularly affected by mitigation actions. Finally, both the Framework Convention and the Paris Agreement require developed states to provide financial and technological assistance to developing countries for both mitigation and for adaptation. The principle of common but differentiated responsibilities and respective capabilities is the main way that distributive justice issues are addressed in the climate change regime. So I want to spend a few minutes exploring the issues it raises. The UN Framework Convention and the Kyoto Protocol differentiate primarily through an annex-based approach, which lists the countries subject to different obligations. Under the Framework Convention and the Kyoto Protocol, Annex 1 countries had quantified emission targets and stronger reporting requirements. Annex 2 countries had financial obligations, and Annex 2 basically consisted of Annex 1 countries minus Eastern European countries whose economies were transitioning away from communism. Finally, non-Annex 1 countries had only very general obligations. The basic rationale was that Annex 1 countries corresponded more or less to developed countries, and these countries should do more. Non-Annex 1 countries corresponded more or less to developing countries, and these countries should do less. And Annex 2 countries excluded Eastern European countries who were not seen as able to assume financial obligations at the time, since their economies were in shambles. This annex-based approach has two problems. First, the list of countries in Annex 1 and the group of non-Annex 1 countries are very heterogeneous, so grouping them all together is hard to justify on distributive justice grounds. For example, if we take an egalitarian approach, which focuses on per capita emissions, while some developing countries, such as India, have very low per capita emissions, the country with the highest per capita emissions is Saudi Arabia, which is a non-Annex 1 country. And interestingly, Chinese per capita emissions are now above those of the European Union. Or if we adopt a capabilities approach, which focuses on ability to pay, non-Annex 1 countries include some of the richest countries in the world, such as Singapore, the United Arab Emirates, and Kuwait. Indeed, the richest country in the world, on a purchasing power parity basis, is Qatar, which is usually grouped as a developing country. There's a second problem with the annex-based approach, namely that the annexes don't automatically evolve to take account of changing circumstances. As a result, they become increasingly outdated. Even if the list of countries included in the annexes made sense in 1992, when the Framework Convention was adopted, the world has changed tremendously since then. Countries that might legitimately have been seen as developing 30 years ago are no longer developing now, and Singapore is a prime example of this. Similarly, while the US was the biggest emitter back in 1992, China has now become the biggest emitter, with almost double the share of global emissions as the United States. So we need an approach to differentiation that can evolve as conditions change. For these reasons, the Paris Agreement abandons the annex-based approach and instead takes a more nuanced, tailored approach to differentiation. First, it adds a third basis for differentiation. The Framework Convention focused on responsibilities and capabilities. The Paris Agreement adds different national circumstances as another basis for differentiation. Second, the Paris Agreement continues to differentiate the financial obligations of parties, but it does so using the general descriptors developed and developing countries, which can evolve, rather than through fixed lists of countries in an annex, which are frozen in time. Third, the Paris Agreement provides for differentiation based on capacity in its reporting and review provisions. Rather than exempt parties from its reporting and review requirements, it requires all parties to meet these requirements. It gives some countries flexibility in implementing the requirements if they need flexibility due to lack of capacity. Finally, With respect to parties' nationally differentiated contributions, there was no agreement about who should do how much. So the Paris Agreement allows parties to self-differentiate their mitigation pledges. One of the most interesting things about the UN climate change regime has been how states were able to reach agreement despite widely differing views about distributive and climate justice issues more generally. One technique was simply to specify what should be differentiated, not why. For example, states could agree that developed countries should provide financial assistance to developing countries, but they didn't agree why, whether it was due to historical responsibility or greater capacity. So they were simply silent about this question. In other cases, they were able to reach agreement by softening the legal character of the differentiation. In Paris, states agreed that developed countries should put forward quantified emission targets now, while developing countries should only move towards that goal over time. But the US and other developed countries were unwilling to accept this as a legal commitment. So the Paris Agreement uses the term should rather than shall. Sometimes agreement was possible through constructive ambiguity. In Paris, countries were able to agree on which countries were not able to agree on which countries in particular should be entitled to differential treatment. So they used general descriptors such as developed and developing rather than lists, as they had done previously in the Framework Convention. Finally, states sometimes sidestepped an issue by allowing each party to self-determine the answer. For example, in the transparency regime, there was agreement that some developing countries would need to have flexibility in implementing the Paris Agreement's reporting requirements based on lack of capacity, but there was no agreement as to which countries would need that flexibility due to lack of capacity. So the rules allow developing countries to self-determine whether they need flexibility due to lack of capacity. Finally, the agreement sometimes uses procedure to try to influence substance. The Paris Agreement allows countries to self-determine their mitigation contributions and to self-determine whether they need flexibility based on lack of capacity. But it requires them to justify their actions, to explain why their NDCs are fair or what their particular capacity constraints are. The idea is that requiring states to give reasons will make it easier to critique their actions and will impose some discipline. Given the lack of substantive agreement about distributive justice, these procedures help make possible a more robust dialogue about justice and hopefully move the regime in that direction over time. In terms of corrective justice, the convention is less clear. Developing countries have long argued that developed countries should be liable for the damage caused by sea level rise, drought, extreme weather events, and other climate-related impacts. These climate change damages could be vast, and developed countries have never accepted that they are liable for them. The issue of corrective justice comes up mostly under the rubric of loss and damage. In 2013, the parties established the Warsaw International Mechanism for Loss and Damage, but gave it a quite limited mandate, focused mostly on facilitation and cooperation in order to enhance understanding and to build capacity and resilience. The Paris Agreement incorporates the Warsaw International Mechanism, but the decision adopting the Paris Agreement specifically said that this does not provide a basis for liability or for compensation. Finally, in terms of procedural justice, the UN climate change regime includes a number of relevant elements. It provides for consensus decision-making. It provides for support to help developing countries participate in the process. And it provides many more opportunities for engagement by non-state actors than most international regimes, including through its choice of venues, through special events, through the so-called action agenda, and through the establishment of a local communities and indigenous peoples platforms, which gives these groups greater voice in the process. Thus far, I've been discussing what we mean by climate justice and how the provisions of the UN climate change regime address the issue of climate justice. The third question I'd like to address is the normative question. Is the UN climate change regime just? Or is its language about equity simply empty rhetoric? Here I'd like to draw a distinction between sins of omission and sins of commission. The sin of omission is failing to do something that would promote climate justice. A sin of commission, in contrast, is affirmatively doing something unjust. We can think about sins of omission versus sins of commission in terms of changes from the status quo. A sin of commission makes the world more unjust. For example, in the climate change context, a sin of commission might involve requiring developing countries to limit emissions in a manner that exacerbates extreme poverty. Or it might involve converting agricultural lands from food production to biofuel production, thereby exacerbating global hunger. In contrast, a sin of omission is failing to take action that would make the world more just. Critics of the UN climate change regime sometimes argue that it exacerbates injustice. For example, because it represents a new way for the global North to exert power over the global South. In my view, there's plenty to criticize about the UN climate change regime, but I think it's unfair to criticize it on the basis that it actually makes poor developing countries worse off. The Paris Agreement contains a number of features to ensure that it will not impose any unjust burdens on developing countries. Nationally determined contributions, which are a central feature of the Paris Agreement, are sometimes criticized on climate justice grounds because they don't require developed countries to reduce emissions by any particular amount. But the fact that countries get to nationally determine their mitigation contributions also protects developing countries against having emissions targets foisted upon them. The Paris Agreement, as I noted earlier, also gives developing countries with capacity constraints flexibility. It recognizes the imperatives of a just transition away from fossil fuels, and it provides that actions to address climate change should be consistent with a party's human rights obligations. So I would acquit the climate change regime of the charge of sins of commission. I think there's much more room for criticism that the UN climate change regime is guilty of sins of omission because it doesn't do enough. There are basically three criticisms of the UN climate change regime for sins of omission. First, that it doesn't provide for adequate levels of emission reductions, particularly by developed countries. Second, that it provides inadequate financial and technological resources to developing countries. And finally, that it doesn't provide compensation for loss and damage. As discussed earlier, how we assess the NDCs put forward by countries in terms of distributive justice depends very much on which approach to distributive justice we adopt. This slide shows how parties' NDCs stack up against 5 different equity frameworks, one involving ability to pay, another involving grandfathering, a third based on equal per capita emissions, and another involving per capita convergence. The gold bar on the left shows the business as usual case for each country. The green bar on the right shows the country's NDCs as compared to 2010 emission levels. The bars in between represent the 5 different equity framework approaches. These calculations show that Russia's NDC does the worst against all of the different equity approaches. The US NDC does more than a grandfathering approach, but less than the other equity frameworks. But even the Chinese NDC doesn't do enough to limit emissions. And the same is true as of India's NDC, which falls short of what it should be expected to do under most of the different equity frameworks. Going forward, models such as these will be very useful in assessing parties' NDCs and can be used to evaluate and potentially critique the equity rationales that parties put forward to justify their NDCs. So far, I've been focusing on the fairness of parties' NDCs. Turning to finance, developed countries agreed in Copenhagen to a goal of mobilizing $100 billion per year in climate finance for developing countries by 2020. This target was extended to 2025 in the decision adopting the Paris Agreement. Although there are lots of disputes about what qualifies as climate finance, developing countries have been making progress towards achieving this goal. And the most recent report of the OECD, which covered climate finance through 2017, estimated that developed countries were on track to achieving the finance target in 2020. To the extent this is true, this is obviously good news, but it doesn't address whether the $100 billion finance goal was in fact sufficient. Looking specifically at adaptation funding, the amount of funding provided in 2017 for adaptation falls well short of what UNEP calculates will be needed by least developing countries, shown in blue, by 2025, let alone the amount needed globally. So to meet the adaptation funding needs of least developed countries, adaptation funding would need to be ramped up significantly. Countries are now considering what the climate finance mobilization goal should be for the post-2025 period. And an important component of those discussions is which countries should be part of the climate mobilization finance goal. The existing goal applies only to so-called developed countries, which do not include China. But given China's enormous economic growth, there's a serious question, should it continue to be exempt from the regime's climate finance goal? Another aspect of corrective justice is compensation for loss and damage due to climate change. As I mentioned earlier, developed countries don't admit that they're liable for loss and damage, but they in fact provide a considerable amount of assistance for disaster relief. To what extent should this humanitarian assistance be considered in assessing corrective justice for loss and damage? That's another important question. Finally, turning to procedural justice, the UN climate change regime is sometimes criticized as undemocratic and not sufficiently transparent, as well as for giving big delegations and English-speaking delegations more influence. It's true that decisions are usually made in the waning hours of negotiating sessions by relatively small groups, usually out of public view. And big delegations have an advantage because they're able to cover many more issues than a delegation with only a handful of people. So these criticisms have some validity, but I think they're overstated. There's usually a significant effort made to include representatives of all of the major groups in the small meetings that take place to resolve crunch issues. And small delegations often have a significant influence on the outcome. For example, the Marshall Islands played a big role in the Paris negotiations by spearheading the creation of the so-called High Ambition Coalition. Moreover, while the current negotiating modalities certainly have problems, the question always is, compared to what? What would be a better way to organize the negotiations? It's almost impossible to negotiate among 190 plus participants, so meeting in smaller groups is essential. And states are unwilling to speak frankly in open sessions, so full transparency would almost guarantee that agreement was never reached. So I don't think it's realistic to expect the climate negotiations to be fully democratic or fully transparent. Having considered what climate justice means, how it's reflected in the UN climate change regime, and how the UN climate regime stacks up against the standards of climate justice, let me turn to my final question. What causal role has justice played in the development of the regime? This question is extremely difficult to answer because the justice-based arguments that countries make almost always align with their self-interests. So it's very difficult, if not impossible, to determine whether countries are advancing justice arguments in good faith or merely as rationalizations of their self-interest. For example, countries with very large populations, such as India, argue for an equal per capita emissions approach, which would give them a very large share of future emissions. Brazil argues that it would be unjust to include emissions from deforestation in calculations of historical responsibility. Meanwhile, fossil fuel reliant countries such as Saudi Arabia and Poland emphasize the need for a just transition away from fossil fuels. And both China and the US oppose approaches that focus on their historical emissions, which are very high. Nevertheless, I think it's possible to discern a number of effects of climate justice arguments in the UN climate change regime. First, the inclusion of equity language and broad principles of differentiated responsibility help frame the discussions and provide standards that states can use to criticize or support different proposals. Second, concerns about procedural justice have led to the provision of funding to help ensure that developing countries are able to participate and are able to undertake mitigation and adaptation actions. Finally, in order to be acceptable, an agreement can't seem manifestly unjust to any group. So views about climate justice at least set bounds on what can be agreed, even if they don't dictate particular results. In concluding, let me briefly recap. First, there are many different theories of climate justice with very different implications. But second, there's a minimum level of agreement about what's unfair, and by extension, a minimum level of overlap about what's fair. Developing countries should take the lead in addressing climate change. Least developed countries should do less. These are the kinds of things that are generally agreed among states. Finally, the UN climate change regime has shown considerable ingenuity in reaching agreement despite different views about climate justice issues. They've done so through agreement on what, not why, through the use of constructive ambiguity, by allowing states to self-determine certain issues, and through the use of procedural rules intended to produce greater substantive justice over time. So with that, I'll conclude, and thank you very much for your attention.
Thank you, Dan. That was great. There's a lot to chew on, and I'd like to invite Dan Esty to begin the discussion. And I suspect there'll be a number of questions from that rich presentation. Dan?
Thank you so much, Professor Torres. Gerald, it's a pleasure to be part of this program with you. Thanks to everyone who's part of the discussion today, and a special thanks to Graciela Chichelniski, who's made this possible with this support in honor of her daughter, Natasha. It is a special joy and a pleasure to follow my longtime friend and colleague, Dan Bodansky. All of us, when it comes to things climate change, follow Dan Bodansky. He is truly one of the leading scholars in the world. And beyond being a scholar, he's got a conceptual brilliance on these issues that is really impressive, informed, I might add, by considerable real-world experience that I admire and think is essential in terms of how we get to answers and how we get good scholarship done. So it really is a special pleasure to follow Dan and his, I thought, towering review of how climate change justice might be understood, how it plays out on the ground, the levels of analysis required, and frankly, the challenges we face in trying to make sense of this extremely important topic. So I'm going to, in just a few minutes of commentary, and then I look forward to the discussion, the back and forth that I think follows, try to give an alternative conceptual framework, but one that builds on in many ways and runs parallel with Dan Bodansky's analysis. And I want to start by saying that it is really an important topic, and I'm so pleased to be part of a conversation about global environmental justice broadly in the international domain, but with particular focus in this panel on climate change. Because I actually think it is issues of justice that have held us back from having a more effective climate change program nationally and globally. And I want to spend a few minutes on digging into that. So the challenge we face today, the thoughts that we're digging into, I think are ones of enormous, in fact, overriding importance when we think about climate change and what will be required to move us towards a future that is deeply decarbonized and puts forward a low carbon energy pathway that we can not only survive with, but thrive with. Because, of course, the goal here is to achieve success in responding to the threat of climate change, but to do so in a way that also supports ongoing prosperity. And in fact, it's the need to ensure that we are achieving ongoing economic success in both the developed and the developing worlds that makes this a particularly tough policy problem. I want to start with something that Dan Bodansky mentioned briefly, but I think I want to dig into it in a slightly different way. And that is, I think, a fundamental issue. And this is one of 5 dimensions of the challenge of climate change justice I want to walk through. But dimension number 1 is the challenge of who is responsible for taking action. And that's the issue that gets a lot of conversation in the negotiations. It's the challenge of burden sharing, as it's often described. And we do have, and Dan walked us through this, some framework ideas about how this should be addressed. with regard to common but differentiated responsibilities and capacities. So we do have some thinking. But I want to start with an even more basic point. And that is, I think we have to ask not only who is going to take action and pay for it, but who pays the price for inaction on climate change. Because I think that has turned out to be a critical reality. And that, of course, is that there are certain nations much more exposed to rising sea levels, to changed rainfall patterns, to the threat of increased intensity of hurricanes or typhoons, and to all of the dimensions of threats to agriculture, more intense flooding, changes in the exposure of forests to fire. All of that does not hit every country the same way. And I think we ended up with a regime in 1992, the Framework Convention, that set us on a certain course. Dan Badansky highlighted the challenge with it. I think it's one of the larger mistakes in international negotiations of the last 50 years. The separation of the world into an Annex I set of countries that was expected to take action on fundamental issues, and a non-Annex I list of countries that were largely invited to sit on the sidelines proved to be a disaster, because it was, in fact, the willingness to allow some countries to sit on the sidelines that became a stumbling block for action in the United States. A Congress began to say, why should we act? Why should we bear costs when some of our major trade partners, some of our major trade competitors are not bearing similar costs? So there was a fundamental unfairness there that's a little different than the kinds Dan Badansky put forward. But I think it became a political obstacle of insurmountable size in domestic politics. So I want to start with saying that both who pays for climate change action is important, but who pays for inaction is important. And frankly, I think the Paris Agreement, which shifted us after 20-something years of inaction to, I think, a more promising platform for climate change action globally, was in part the conclusion from a number of developing countries that they needed to join the action. They needed to get on the field and start to play the game of trying to change us to a decarbonized future. And the willingness of those developing countries to step up with the Paris Agreement, to make nationally determined contributions to the global response, I think is an important step towards achieving a successful outcome and, frankly, overcoming a breakdown on this question of burden sharing, of who is going to do what. So again, dimension number one, absolutely critical, is the issue of action versus inaction, and the recognition that inaction, as the status quo might be called, imposes huge costs on certain countries and is in fundamental ways a profoundly important issue of fairness, or should we say unfairness. So second of all, I want to talk about the role of fairness within nations. It turns out, I think, that fairness within nations can be an important foundation for fairness more broadly. And I think the United States, in part, has had a challenging time getting into the international conversation in a serious way, stepping up to its obligations, because there was a deep sense of worry about there being some segments of American society likely to be fundamentally dislocated by a commitment to serious climate change action. So I think that we've now seen an important change in the framework of the discussion. I think there's a lot of talk now as people begin to put forward climate change action plans with the hope that a new administration in January will move this issue forward. But there's now a lot of talk about a just transition. And that strikes me as absolutely critical to changing the dynamic in the United States, getting people ready to move together towards a serious response, and to bridge, frankly, the Republican-Democrat divide. And I think in this regard, three dimensions of domestic, intra-United States justice are going to be critical. One is how we make sure that the low-income segment of our society does not bear an unfair burden of moving forward on climate change. Second, we're going to have to do something for the communities that have been economically dependent on fossil fuels. We might call this the West Virginia issue, but of course there are other communities in the Dakotas, in Texas and beyond, where the same question of how do we help these communities move beyond their current fossil fuel dependence from an economic perspective will be essential. And third of all, I think there is going to have to be something done to address the fact that rural people often have a more carbon-intensive life experience and livelihoods than those in cities. And we're going to need to make sure that the burden of change, of the movement to a decarbonized future, the movement to low carbon fuels and a future that is based on non-fossil fuel alternatives doesn't weigh them down in ways that would be seen as unfair. So again, the second dimension of justice, I think, is the intra-country dimension with important consequences for the possibility of action globally. Number three is fairness across nations. So inter-country environmental justice, or in this case, climate change justice. And I think Dan Bodansky's given us a very useful perspective here. It's clear that we can't think about this in the old terms of the 20th century, North versus South, developed versus developing. The world is much more spread out economically now, and a more nuanced approach is required. I think the Paris Agreement does a quite brilliant job of getting people step up to the issue commensurate with their capacity. And that really is what we want. And I think it is an issue for every country to determine. And I think we're seeing now a more variable response across nations in a way that can be unfair if some countries choose to do very little when they should do much more. And Dan has pointed out that Russia would be the real laggard in this regard. But it's also the case that there is complexity in getting everyone to pull together. This brings me to the sort of fourth dimension. Again, Dan mentioned it, but I want to highlight it. And that is fairness across time. One of the fundamental challenges of climate change as a policy issue is that it does require not only attention to the spread of harm across the world now, but the fact that these harms compound over time, and we are leaving our children, our grandchildren, and those beyond with potentially a serious problem. So I think we have not addressed in a serious enough way intergenerational fairness in this conversation, but it is an important element, and I think an important element of what is now we see going on around the world, and that is the rise of young people pushing back on inaction, saying, folks, this inaction point falls mostly on the young across the world. So Greta may only be one woman from Sweden, but she is a voice for young people everywhere who have basically said, when you decide on inaction, you're deciding against our futures as young people. And that is unfair and unacceptable. So I do think we've seen the rise of the intergenerational element of global environmental justice, global climate change justice emerge with particular force in the last couple of years. The fifth dimension, which Dan Bodansky did talk about, is procedural justice. Are the discussions around climate change open to people, particularly disadvantaged communities? Are there ways to ensure that indigenous communities, frontline communities, communities that wouldn't otherwise have the resources to participate in the framing of policy responses, are they brought into the system? And I actually think, along with Dan Bodansky, that the international system has done a pretty good job of hearing these voices. Better could always be done. There need to be more ways to bring them in, but it's actually not so bad. So that's, I think, 5 dimensions of the global environmental justice issue that need to be considered. This issue of action versus inaction, fairness within nations, fairness across nations, intergenerational equity, and then procedural justice. All, I think, are important. I want to make 2 more points and then open this up for the broader conversation after we have our final commentator. One is, I think it's time for a foundational principle that might help us address all of the disputes that Dan Bodansky walked us through, all of the dimensions of challenge here, of getting people to come together. I would like to see a central framing around what has long been understood to be, or talked about as, the polluter pays principle. I think it can also be framed in the terms of economics as a commitment to end externalities. And an externality, of course, is something that is imposed as a cost on society rather than borne by the person causing that issue. So a factory that sends smoke up a smokestack or effluent out a pipe into a nearby river has externalized part of the cost of production onto the community around it, or in the case of greenhouse gas emissions, onto society globally. I think we need an end to externalities, at least unpaid for externalities. And I think we should have in every nation a commitment to hold those who are causing harm accountable. If you're spilling harm onto others, you either have to stop or pay for it. And I think that would give us a starting point for justice on all the dimensions I've talked about. It would allow us to address justice within societies. It would allow us to address justice across societies. It would allow us particularly to address justice over time. So that's my big picture idea. Let's make the polluter pays principle serious. We can have a further discussion about what price people should actually pay, but I am happy to have any price paid. There are lots of efforts to establish a social cost of carbon. One could auction off allowances. One could set a slowly rising price of carbon that would move from a perhaps low rate of $10 or $20 a ton today out to $100 a ton across several decades, all of which would allow a signal to be sent to those who are causing these emissions that they need to change their practices. They need to innovate. And frankly, I think a spur to innovation is one of the most powerful reasons to put a price on harm causing, to make that a central policy feature, and frankly, a central element of how we achieve justice on climate change. My final point is that I think, and the topic of our panel is in fact looking not only at climate change, but frankly at international institutions more generally. And I think that is, of course, the topic of our entire conversation over several days. But I would like to suggest that we need to have the international regime beyond those focused on climate change take seriously the 2015 Paris commitment to real action in every country and across the world by having other parts of the international regime step up to a responsibility for aligning their work with the global commitments made in that Paris 2015 structure. This would, of course, start with the World Bank and the other multilateral development banks and include all of the international financial institutions who should make sure that the money they lend and the funds they put forward are done in a way that does not increase greenhouse gas emissions and rather is attentive to the commitment now of really almost all nations to reduce emissions over time. So a fundamental shift in the mission of our development banks in particular to ensure that they are climate change aligned and that their practices and procedures are fulfilling a need for society broadly to bring emissions down over time. Second institution that's really got to be called into account on this is the WTO, the World Trade Organization. Lots of the issues where the tension between economic growth and environmental progress really come together occur in the realm of trade. So we need to take a hard look and frankly a reform agenda to the trading system and change both the rules of the Global Agreement on Tariffs and Trade and the procedures of the WTO and other trade agreements and change them to ensure that they are promoting reduced greenhouse gas emissions over time and certainly not undermining national efforts to bring this about. And I would say at the same time, we should be looking at the Food and Agriculture Organization, the World Health Organization, the World Food Program, the UN Development Program, all to be asked to go through a careful exercise of thinking about how to achieve alignment with climate change goals to ensure that their work is not adding to the difficulty of getting a world community to respond and achieving climate change justice. So let me close by saying that I think we have put forward, Dan Bodansky, thank you again for doing so, a really important perspective on this issue of global environmental justice, global climate change justice. I think Dan Bodansky in particular, and I hope the conversation continues this, gave us a picture of the sweeping dimensions of this issue, the challenging complexity, frankly, the intractable disputes over ends and means that are plaguing us, the fact that there are deeply contested values and divergent senses of what fair and equitable might look like. But altogether, I think we can agree that it remains an issue of fundamental importance, essential to forward progress in addressing climate change, both at a national level and globally. Thank you very much. Look forward to the discussion to follow.
Thank you, Dan. That was a gripping discussion, set up, I think, many more questions to be addressed, and gave both Dans gave us a good framework to try to push the discussion forward. I'd like to invite Michaela Foster to the stage to hear her comments. So, Michaela.
Hi there. I'd like to start by thanking Dr. Bodansky for that wonderful review of justice and the UN climate regime. And I'd like to also thank Dr. Esty for his thought-provoking commentary. I'm going to center my comments around 3 areas and pose some questions around complexity, the influence of justice in advancing climate action, and on moments that propel transformative change. In his talk, Dr. Burdansky gave us a great conceptual framework for how we might understand justice within the climate regime, describing distributive, procedural, and corrective justice, and then walking us through how the ways in which we frame justice affects key aspects in the climate regime, including how the climate problem is framed, what actions are appropriate to take or feasible, if and how countries will participate, as well as ultimately on what agreements are reached. And also as well thinking about whether or not the UN climate regime is seen as a just institution. His talk to me showed just how complex the climate issue is, as well as how complex international cooperation and the negotiations are. But what I found really interesting was that the ability of states to embrace this complexity, the complexity associated with the climate problem, with incorporating justice, and in deciding how to take action, highlights to me just how important and potentially transformative the Paris Agreement is for not only the UN climate regime, but also for the climate justice movement and for all of us as we work towards building a sustainable and just world. We saw a lot of focus on complexity with regards to inter-country justice considerations, but I'd like to take a minute to talk about how we might also see this complexity when we talk about intergenerational, and as Dr. St. talked about, intra-country equity. When we think about intra-country equity, there are a lot of questions about, how will different groups within states be affected by decisions made to address climate change? Will there be differences across groups in terms of the impacts, as well as the benefits from mitigation and adaptation action? And it's also important to consider factors like exposure to climate risk, poverty, and income and racial inequalities. Will these factors be worsened by whatever action is taken? And so adding this complexity makes it very difficult to decide on which actions to take. But I think it also forces us into an opportunity to consider how actions in one area might be synergistic and help us to address problems in other areas. Which brings up an interesting question, which is how can the coupling of issues on climate with efforts to address social problems like structural inequalities be an opportunity to gain more support for transformative actions that allow us to tackle both the climate crisis as well as some of the other social crises that we face in many countries. And turning to intergenerational equity, and that's where we're thinking about how future generations will not only bear considerable costs if action isn't taken now, but also will be in a worse position to address climate change. And I think one way that complexity can enter the conversation here is when we think about how we've so far framed this issue of intergenerational equity. It seems to me that the sort of common way of understanding this is by focusing on cost and benefits. Future generations are entitled to the same benefits that we have now, and they shouldn't have to bear excessive costs that we do not. But perhaps there are other ways to frame this. There's been a phase out of microplastic beads in cosmetic products in the US, and this hasn't really been motivated by a cost-benefit rationale. Instead, there's been a strong environmental norm that has emerged that pollution from these plastics is dangerous and unacceptable, and that has really spurred the phase out of these microplastics. And I think another example that makes this point very clear is thinking about how now it would be totally unthinkable to think about chattel slavery with a cost-benefit framing. The normative and moral arguments against slavery are so strong that it would be unimaginable to try to think about sort of tweaking the calibrations of that type of institution. And the point to take away from that is that how we frame the problem affects what solutions are proposed, as well as to what extent people are willing to make significant and timely changes. And when we think about the intergenerational argument, perhaps we might consider a reframing away from, conversations of what's the appropriate discount rate towards perhaps a more normative argument that might motivate further climate action right now. And just a final thought on complexity, and that is that we're dealing with an incredibly complex issue, but I think that understanding and embracing this complexity might serve as an opportunity for us to generate new ways of thinking, as well as new ways of acting that will allow us to reach our global climate goals. And this relates to my second point that I'd like to consider, and that is around the power of justice in advancing global cooperation and climate action. It was interesting to me to hear that, how justice is not explicitly referenced in the UN climate regime, but that justice arguments are being used to come to an agreement, and that justice is being addressed in many ways throughout the climate regime. And Dr. Bodansky pointed out several examples of that. And I think this is reflective of a shift in how we're thinking about climate change and climate action. We're seeing a new framing of the climate problem as a human rights and a justice issue, and that's gaining traction. And we're seeing a shift in how we think about development and our future trajectory. We want a development that is not only sustainable, but also inclusive and just. And any action that we take on climate needs to be just. And this shift brings up an interesting question for me, which is how might a focus on justice motivate further climate action? I think we're starting to see this with youth activists and the climate movement. And this movement has been able to mobilize and inspire a lot of people by linking these issues. And we're also beginning to see innovative solutions being proposed that try to tackle multiple considerations. You might think of something like an aviation tax that would fund adaptation, or policies that promote leapfrogging to clean energy to address energy poverty. It also brings up questions about how action on justice issues contribute to effective climate action. How might a focus on justice address some of the intermediate factors like conflict that have limited states' abilities to act on climate? And for my third point, I'd like to zoom out a bit and think about the Paris Agreement as a marker of change, as a signal of the shift in our recognition that environmental sustainability, development, and social justice are intertwined. Something that I think about quite a bit in my own research is this idea of moments, or times when certain policies or events seem to matter more than others and have a significant effect. And the idea of moments can be conceptualized in many ways. You can think of these as critical junctures, as turning points, triggering events, or movement moments. And the key feature of this is that these moments are important for setting the subsequent path. And we can see these moments when we look back in history. The first Earth Day in the United States in 1970 can be considered one of these moments. On this day, 1 in 10 Americans came to the streets to raise awareness about environmental problems. And many argue that this first Earth Day led to the creation of the US Environmental Protection Agency and to important legislation like the Clean Air Act and the Clean Water Act. More recently, I would say we've also lived through another one of these moments with the murder of George Floyd in the United States. His tragic murder at the hands of the American police was a spark that galvanized people to organize. This organization built on the foundation that had already been established by the Black Lives Matter movement, and the organization was in support of that movement to bring social and racial justice to the United States. And it led many people to reconsider some of our societal institutions. It is left to be seen what the long-lasting and most significant effects of that will be, but nevertheless, to me, that's a critical moment where I can identify as a moment that is spurring action. This concept of moments I find quite interesting, especially in thinking about how at certain times and through certain means, we can set a way forward, which I think is especially relevant for climate action and thinking about what we need to do now to limit future global warming. And so I'll just leave you with 2 questions to initiate some thoughts on moments in regard to the climate regime. How might the UN climate regime work to initiate these moments of transformative change for climate justice? And finally, how might the UN climate regime or the Paris Agreement be leveraged as opportunities to further real and impactful climate action to ensure a sustainable and just world. Thank you all very much, and I'll hand it back to Dr. Torres.
Hi, so I think we're going to wait for Dan Budansky and Dan Esty to come backstage, and then we can have a discussion. That was fabulous. Nice to have you all back here. I just want to say that was about 3 of the most inspiring and uplifting discussions I've heard on climate justice and climate negotiations. And I think the best thing I can do right now is get out of the way. And I'll start with just saying, Dr. Budansky, do you want to respond to some of the ideas put forward by your colleague, Dr. Dan, and Michaela Foster?
Yeah, well, thanks very much. And thanks, Dan and Michaela, for those comments, which were fabulous. So I just wanted to make maybe just a few quick points in response to the comments. I really didn't disagree with anything that was said. I viewed them all as friendly amendments to what or additions to what I said. But just a couple of things. So Michaela asked at the end, how might the climate change regime initiate moments? And I think there certainly moments for change have been very important in the development of international environmental law. And I think actually the idea of the Paris Agreement is to try to build these moments in every 5 years through the ambition cycle. So one of the things that Paris did, in addition to having the actual agreement, was to provide a political moment where there was significant political pressure on states to come forward with stronger actions on climate change. And so countries put forward their nationally determined contributions, basically, because Paris was such an important political moment. And I think even though the nationally determined contributions fall well short of what's necessary, they're still a lot better than what countries were doing before. And the idea of the ambition cycle under Paris is to every 5 years have a global stock take to see how the world is doing in addressing the goals of the climate change agreement. And then countries are supposed to come back with new, updated, nationally determined contributions that are informed by the outcomes of the global stock take. So that's the idea there, is to really build in these political moments every 5 years. Whether that's successful or not, we're going to see in 2025 when the next round of NDCs will be due. But that is, I think, the idea of the Paris Agreement. So Dan, you in your comments distinguish between justice among countries, justice among individuals, and justice between generations. And I totally agree with that. I was focusing primarily on justice among countries because my focus was on the UN climate change regime, which is interstate and primarily focused on the interstate level. But I think it's just worth noting that there are a few ways that the Paris Agreement does address the other two. So there's been a significant effort now to think about NDCs and what countries put forward, not simply in terms of what they're doing to address climate change, but also in terms of how what their implications are internally and how do they advance climate justice within countries. So there's a significant, for example, interaction between the NDCs and the Sustainable Development Goals to see how well a country's NDC actually, how consistent it is with the Sustainable Development Goals. And you can do nationally determined contributions in ways that are not very productive for climate justice, but you can also try to make them attentive to justice among individuals. For example, by focusing on vulnerable communities, by having renewable projects that increase access to energy by disadvantaged communities. So in terms of how you take climate action under the Paris Agreement, what you put forward, it can be done in ways that are either more or less just in terms of internal justice, justice among individuals. And I think there's increasing focus on that in the NGO community. WRI had a big report on that, looking at that. And I think they're trying to encourage countries when they're assessing each other's NDCs to looking not only at how equitable and ambitious they are internationally, but also their internal dimensions. And then in terms of justice among generations, of course, the whole idea of the Paris Agreement and the 1.5 degree goal is to prevent, catastrophic climate change. And so that's really primarily, of course, will have effects on our generation, but it's primarily for future generations because the effects of climate change are going to be very long term. So I think you can think about the temperature goals in the Paris Agreement as sort of a way that the climate change agreement is trying to address the issue of intergenerational equity or intergenerational justice. So I think the two comments on my talk illustrate two very different framings or ways of thinking about how does change happen? How do we get change on the climate change issue? So Dan's focus very much an economic focus, pricing mechanism, trying to put a price on carbon, polluter pays principle. Michaela's focus was maybe more on the moral dimensions of climate change and thinking about climate change. We think more about chattel slavery as something simply immoral. And so the question is, I guess as a lawyer, I can afford to be agnostic as to how change happens. I think change can happen in either of those two ways. I think people respond both to economic incentives, but they also respond to moral imperatives. And there's a great book by Anthony Appiah, the philosopher, about how moral revolutions happen and how people think about themselves, what is considered to be an acceptable mode of behavior is motivating huge changes in how people, what they think is okay to do and how they then behave. So I would say, both of these could be avenues. So I would, I'm let 1,000 flowers bloom kind of person on this. I would, so I think the youth movement is focusing on climate change much more as a moral issue. Others are focusing more on climate change as an economic issue. I don't know which is going to be more successful. I wouldn't know where to put my money if I had to bet. So I think they could both be productive. I guess the one caveat I have about thinking about climate change purely as a moral issue is the effects of climate change in your actions are so attenuated from the actions that I think it makes it more difficult for a lot of people to think about it as a purely moral issue. It's not like, most moral issues, the effects are much more immediate and visible to the actor, whereas whether you turn off your lights when you go out the door to save electricity, the effects of that on a island state in terms of sea level rise are so attenuated. I think most people have trouble making that connection, which makes it more difficult to think about purely as a moral issue. So, but I think perhaps that can, whether we think about every time we get on a plane flight that we're acting immorally, I'm not sure if that's going to be the case, but
I think you could say the same thing about the economic argument. That the economic argument is also so separated in time and space from the action. That's why people are so hesitant to pay more now for a more expensive plane ticket or something, right?
But if you make the polluter pays and build the price in directly, people know immediately whether they're paying $300 for the plane flight or $400 for the plane flight. To the extent prices matter to most people, which they do, then it's going to have an immediate effect. Whereas the effect of the plane flight on, Vanuatu is more distant. So Dale Jamieson, the philosopher at NYU, the ethicist, I had a book where he's trying to make that argument about the limitations, perhaps, of morality as being the primary motivator for change. But I think, it's possible it could be. And so I guess I would, be happy if people were pursuing all of these different avenues.
And Dan, I would say that my argument is one fundamentally about moral justice. It's about saying it's not okay to impose harms on other people, and you should either stop them or pay for them. So I consider that to be actually a blending of an economics argument with a moral argument, and in fact, trying to make actionable the moral. And I would also just say, in response to those who worry that the environmental price signal type approach isn't going to get us where we need to go, I think the moral argument hasn't gotten us where we need to go. And I worry that some moral wrongs have persisted for long, long periods of time. Just to pick up on Michaela's point, slavery persisted in the United States for hundreds of years before a moral force rose up against it. So we certainly wouldn't want that slow roll of moral justice to bend the arc of history here over 200 years, because the climate change world would be deeply in trouble if we wait that long. So I am hopeful that people will see this press for making the polluter pay as a practical way to operationalize a moral claim, and in doing so to drive us towards action quickly. And I do think there's some international examples that work, not a perfect parallel, but the fact that we saw a commitment in the Montreal Protocol to phase out, and then with the London amendments, or phase down and then phase out of CFCs. And in many places, including the United States, that was done by putting a price on those CFCs, taxing them until those using them found alternatives. So there are, I think, arguments that, especially internationally, giving each country a chance to work on its own approach, but using price signals might be a way forward.
Dan, if I can just ask you a question. When you're talking about a polluter pays principle, it can be used in two different ways, sort of future-oriented or backward-looking. Backward-looking is the historical responsibility idea that there should be a corrective justice idea that polluters should pay for the damages that they've imposed on others in the past, as opposed to a pricing mechanism that encourages change in behavior going forward. And I'm just curious, I know you think it's forward-looking, but do you also include backward-looking? Would that be a basis for reparations or for compensation for loss and damage looking backward?
Well, I'm eager to do whatever is politically possible. I think agreement on the backward-looking dimension is politically impossible. So I'm focused on the going forward piece, which, by the way, I don't think is easy. So let's be very clear. I don't think any of this is easy. And Dan, you did a fantastic job showing us the layers of challenge. But I think it's imaginable. And that's why one of my core ideas is the slowly rising carbon charge, which I think allows people to get used to the changes they're facing, to adjust behavior. For people that made big investments based on prior assumptions about what was okay, they would have some time to get out of them, to switch out of their power plants, or even just at a personal level, the gas guzzling car. If you know that you're going to pay more in the future, the next time you buy a car, you change. So I'm more focused on the forward-looking than the backward-looking dimension.
Well, I want to read one of the questions that's gotten the most upvotes is a group of people would like to ask, what are the more practical ways we can motivate aggressive action on climate change when there is such a disconnect between those who bear the consequences of inaction in space and time and those who bear the cost of action? So just wanted to put that out there and get your thoughts on that. What are the most practical ways to motivate aggressive change?
I wish I knew the answer to that.
I want to hear Michaela on this, because I do think this is where the young have to lead the not so young.
Yeah, I think there's a lot of power in organizing and mobilizing groups. I think one of the biggest challenges is how do you sustain energy once you've mobilized and organized, and how do sort of certain groups, like if we think about sort of youth activists or climate groups like the Sunrise Movement, how do those groups get into places where they're able to have discussions with the people in power, and how are they able to motivate the people in power who are making decisions to make those changes? But I do think there's a lot of power in sort of standing up and grouping together and making a show that, at least for my generation, that we want something different, in the hopes that spurs action, at all levels, at individual levels, but also at the state level.
Yeah, I think that's a beautiful place to end. I think, but did Dan want to? You're about to start to say something.
I was going to say, I think what that highlights, and I think actually unifies all three of the presentations you've heard, is a recognition that these different aspects actually link together. That the access to the conversation that Michaela is talking about, the procedural justice that Dan Bodansky was talking about, actually inform and shape the substantive outcome of the inter-country. And I think I was trying to argue, and Dan, this is a response to your commentary, I was trying to argue that the intra-country conversation shapes the inter-country conversation, and the intergenerational is now shaping the inter-country conversation. And that the young people insisting on action, which is the intergenerational push, I think is actually helping to spur on some ambition in the inter-country conversation.
Yeah.
So these different dimensions I see as useful to pull apart. And Dan, again, thank you for conceptually giving us a very rich framework.
Yeah.
But I think we might want to even close by saying we need to bring them back together. And that's what I see as essential here.
Yeah, no, I have to agree. I mean, there is something that came out of absolutely every single talk that we've had that I sort of have picked up on and think is so important. I've often worried more about the inequities within countries than between, quite honestly. And you see that around issues. My personal one is the concern around the impacts of the UN Red on Indigenous peoples and their land rights and their ability to have a self-determination over how to move forward and have sovereignty over their own lands. But I feel so strongly about Michaela's comments on there are moments. And when moments happen, grab them and act with precision and full force. I think we've definitely seen some of those moments now. And I love the thought of getting to a moment in time where the thought of allowing a polluter to get away without paying is so immoral that we couldn't even imagine it. So I think you three have given us so much to think about. So thank you, Dan Bodansky and Dan Esty and Michaela Foster. That was truly tremendous. And